Welcome to EU Privacy for All, Session 30 on GDPR, Article 14, Information of data subjects who did not provide any data to the controller. Article 14a was replaced in the end by Article 14 on the information to be provided where personal data have not been obtained from the data subject. It stresses that where personal data have not been obtained from the data subject, the controller has the obligation to provide the following information: the identity and the contact details of the controller and, if any, of the controller's representative, the contact details of the data protection officer, where applicable, the purposes of the processing, as well as the legal basis of the processing, the categories of personal data concerned, the recipients, and, where applicable, the controller intending to transfer data. In addition to the information referred to in paragraph 1, the controller shall also provide to the data subject the following information, because it is necessary to ensure fair and transparent processing. That is to say, the period for which the personal data will be stored, and, if that is possible, the criteria used to determine that period, the legitimate interests pursued by the controller or by a third party, the existence of the right to access data, rectify, erasure, restriction, the right to object, and the right to data portability, and where processing is based on consent, the existence of the right to withdraw consent at any time, the right to lodge a complaint with the supervisory authority, and from which source the personal data originate, whether it came from publicly accessible sources. The existence, finally, of automated decision-making, including profiling, referred to in meaningful information about the logic involved in such a processing. The controller shall provide this information within a reasonable period after obtaining the data, at the latest within 1 month. If the personal data is used for communication with data subject, it will be at the latest at the time of the first communication to the data subject. And if a disclosure to another recipient is envisaged, it will be at the latest when the personal data are first disclosed. Where the controller intends to further process the personal data for a purpose different than the one justifying the initial collection of data, such information should be provided clearly to the data subject. Paragraph 1 to 4 shall not apply where the data subject already has the information, where the provision of such information proves impossible or would involve a disproportionate effort, or when obtaining or disclosure is expressly laid down by union or member state law. Finally, where the personal data must remain confidential, subject to an obligation of professional secrecy regulated by union or member state law, including a statutory obligation of secrecy. Key provisions in the GDPR come from recitals 39, 60, 61, and 62. In the first recital mentioned, it is stressed that the lawful and fair principles should be respected, based on a transparent information of natural persons, that is to say, providing an information that would be easily accessible and easy to understand in a clear and plain language, making really clear all the set of risks, rules, safeguards, and rights in relation to the processing, the specific purposes for which personal data are processed should be explicitly mentioned. Recital 60 shed light on the fact that fair and transparent processing required that further information necessary to ensure a full and transparent information would be provided. That is to say, for instance, on profiling and its consequences, on the obligation to provide data and the consequences of not doing so, and also raises the point that the information may be provided in combination with standardized icons in order to give an easily visible, intelligible, and clearly legible way a meaningful overview of the intended processing. Where those icons are presented electronically, they should be machine readable. Recital 61 also sheds light on the fact that at the time of the collection from the data subject, it is necessary to disclose where personal data can be legitimately shared with third parties, but also when there is an intention to further process data for a purpose that would be different of the one justifying the initial collection. Additionally, this recital raises a key point in the end, stressing that where the origin of personal data could not be provided to the data subject because various sources have been used, general information only should be provided. Recital 62 also mentions that, however, it is not necessary to impose the obligation to provide information where the data subject already possesses the information, that is to say, where the recording or disclosure of personal data is expressly laid down by law, or where the provision of information proves to be impossible or would involve disproportionate efforts. Article 57(1)(e) also leads that, without prejudice to other tasks set in the GDPR, each supervisory authority shall, on its territory and upon request, provide information to any data subject concerning the exercise of their rights under the GDPR, and cooperate with supervisory authorities in other member states to that end. The Directive 95/46 lays down in Article 11 on the information where the data have not been obtained from the data subject that member states shall provide that the controller or his representative have an obligation to disclose data at the time of undertaking the recording of personal data or of disclosure to a third party, or not later than the time when the data are first disclosed, provide the data subject at least with the following information: identity of the controller, purposes of the processing, and any further information such as categories of data, recipients, and existence of a right of access to and right to rectify the data concerning the data subject, insofar as such further information is necessary to guarantee fair processing in respect of the data subject. This obligation shall not apply where, in particular for processing for statistical purposes or for the purposes of historical or scientific research, it proves impossible or would involve a disproportionate effort. However, appropriate safeguards should be guaranteed. What should accountable data controllers get prepared for? They will have to inform data subjects on data processing concerning him or her when the data is not obtained from them. They will have to provide this information in an easily accessible and easy to understand way. The information shall be provided at the latest, generally speaking, within 1 month, or at the time of the first communication to the data subject, or at the latest when the data are first disclosed to third parties. The obligation will not apply if data subjects already have the information, or disclosure of data is laid down by law, or if it proves impossible or would involve disproportionate efforts. The information shall include the identity and contact details of the controller and, if any, of the data protection officer, the purposes and legal basis for processing, the categories of data, the recipients, the transfers, and any further information such as legitimate interest, storage period, rights of the data subject, the right notably to withdraw consent at any time or to lodge a complaint to a supervisory authority, from which source the personal data originate, and if there is any automated decision-making process such as profiling. So the concrete implementation and the meaning of meaningful information shall still be specified.